Hello and welcome to Quadcast, Quadrant Chambers discussion forum. We look at news, hot topics, legal developments in the world of commercial litigation. We are four barristers from London, Quadrant Chambers. My name is Paul Downs, Poonam Malwani, Claudius Wilmot-Smith and Joe Sullivan. And you can join in. You can join in by sending us chat in the YouTube chat function, or you can email us, quadcast@quadrantchambers.com. Send your comments and questions. We've got a controversial show for you this afternoon, I promise you. But before we turn to the topics we're going to debate, let's do some news and catch up. Who's going to go first? Poonam.
I had the most fantastic weekend, which is kind of difficult to believe in lockdown. But do you guys actually realize what happened this weekend? We had the Six Nations come back and 3 different matches. It was the Super Bowl, which I stayed up with my entire family till 3 a.m. It was got to be the most boring Super Bowl that I remember. And then this week, the Australian Open started. And yes, Claudia, Raf is playing today and I've recorded it and I'm going to be saving that for my night streak. So I've been full of adrenaline all week, fitted in a bit of work here and there, and I'm a really, really happy bunny. Joe, please don't talk about Liverpool. Do you have some news about what you've been up to, honey?
Well, also some sport, slightly different sport, but I'm trying to watch as much England cricket as I can.
Not a sport.
Game,
not a sport.
No, hang on, you thrashed India, so Queen, you choose something else to talk about.
Okay, well, the other thing that I've been watching, again, as much as I can, is the impeachment trial, which it features some interesting advocacy and tactical choices, which maybe we can all reflect on in our own practice. How about you, Claudia?
Well, my news isn't so much what I've done so much as what I've managed not to do. So my cat Spartacus, who regular viewers will know because he's an unfortunate little pussycat and keeps strolling on screen, is currently asleep behind my laptop. I live in fear of him just like appearing at a judicial hearing and meowing really loudly because that's just the kind of thing that he does. And now all hearings are from home. I just like live in fear. But I was pleased to see that at least even if he appears, I don't appear as a cat, unlike this guy from Texas who you've probably all seen, who had a Zoom filter on.
Unbelievable.
And the judge told him about it, and he assured the judge he was quite content to carry on. He was not, in fact, a cat. So I guess I'm just pleased that I am.
Or a bandit or a rabbit looking
I wonder how you do that with these filters these days.
I immediately regret making this my news item.
I've now got to work out how to switch it off.
I mean, doesn't that beg the question? You know, we see all these people who look like humans, but is it really cats?
Oh, John.
You can do beards as well. Do you see that? Look at that.
Well, you know what you've been doing this week, Paul? You've been practicing weird disguises.
You would never know. That's clever, that technology, I think. That's quite clever.
That is horrifying.
Get rid of it. My news is I've been getting really cross about this parish council meeting. You've all seen that, this thing that's gone viral. Because, I'm sorry, but it's Jackie Weaver, wasn't it? Jackie Weaver? She was totally to blame. If you watch the whole thing, she had no legal standing.
I think the phrase is
you have no authority, right, Joe?
But she was brought in to work the technology, so she just kicked the chairperson out. It's outrageous. And everyone's saying, oh, what a wonderful hero she is. Anyway. There you are. I just got cross about that.
I thought you were going to compare their arguments with us on Quadcast, but at least you stayed away from that.
No, we're mild compared with some of the emotion there, but I sort of sympathise with some of them. Anyway, look, enough of that, enough small talk. We're here to talk about Practice Direction 57AC. That's the first topic we're going to look at this afternoon. This is the change now to the way that we do witness statements. It all started, it started with a meeting in March 2018. The commercial court judges got together and they said, you know what, I had a lovely afternoon down at the Crown Court on circuit, and I rather like the way they do those witness statements, or they don't do witness statements there, but none of this faffing about reading pages. They just get the witness in the box and they do it in chief. So they thought that was rather a better way of doing things. So the meeting led to a working group. The working group led to an expanded working group. It was a commercial court working group, then it became a business property court working group. That became a report, and then that's led to this rehashed practice direction that is going to be run as, I think, on a sort of a test basis, a trial basis initially. And I've got a lot to say about this. But anyway, Joe, just give us an outline about how this practice direction
Hang on, Joe, before you do that, let's be clear. It doesn't come into effect yet, right, guys? It comes into effect in April.
Statement signed after the 1st of April, is it?
So it's quite soon, actually.
Yeah.
So if you're
particularly soon when one considers how broad the changes are, I think.
Yeah, if you're proofing now, you need to keep it in mind. But Joe, what does the practice direction say?
So it begins by saying where it applies. It's in the business and property courts, as Paul said. It only applies effectively to witness statements for trial, so not to witness statements for applications and things like that. It's the practice direction sets out the purpose for witness statements for trial, which is to give the evidence that the witness would have given if they'd given evidence in chief orally. The key paragraph is paragraph 3, which really sets out the new rules. So the witness statement must only contain statements of evidence of facts that need to be proved by witness evidence. That means evidence that that witness could and would be asked if they gave evidence in chief. It can only be the personal recollections of the witness. And if and to the extent the witness has been referred to documents as part of the proofing process, then the witness needs to list and say what those documents are. And the evidence should be prepared by reference to and in compliance with a statement of best practice, which has been published alongside the new practice direction, which I think Claudia is going to talk about shortly. Then there's a new and longer statement of truth that the witness has to sign, saying that it is that the evidence of their recollection, and they've explained how well they recollect the matters that have been set out in the statement. There also has to be a certificate of compliance, which is to be signed by the legal representative, just a defined term in the practice direction, effectively confirming that there has been compliance with the requirements of the practice direction. And
who is the legal representative, Joe?
Well, that isn't defined. Well, it isn't clearly defined as to who that should be within, say, the solicitor's firm who is acting in the case. I think that may be due to there being differences between cases and depending upon the size of the firm about who the appropriate person would be.
Well, because they have to do two things, right? The legal rep is defined as the person who has responsibility for ensuring that the trial witness statement and proper practice has been adopted and it's all good. But the same person also has to sign that that's all been done, that the witness has had it all explained to them properly, and that the way the solicitors have done it also complies with their obligation. So it's a double thing.
Yeah.
And I mean, is that going to be the junior who proofs the witness or the head of a department?
Well, it could be either, couldn't it? I mean, I think it would depend on a case-by-case basis as to who that person should be by reference to the explanation in paragraph 1.
And did I catch something in the news? It's up to 10 years in prison if you sign the false one or something.
I think it's just 10 years in prison for anything now.
It's across the board now. CPR sanctions. About time.
Well, that's actually the final part of the practice direction, which is setting out sanctions for breach. And there's not an exhaustive list, but it gives examples. So could be no permission to rely on the statement, could be an order for it to be redrafted, could be adverse costs, or it could be a requirement that the witness must give their evidence in chief. And there's also an anti-avoidance provision. So what you're not allowed to do is go off the record so that then there's no requirement for a certificate of compliance and then come straight back on the record afterwards.
Who would do that?
I know. But anyway, there is this statement of best practice, Claudia. What's that all about?
Good question. I mean, the first statement the first of the principles is, I think, the hardest. Says any trial witness statement should be prepared in such a way so as to avoid, so far as possible, any practice that might alter or influence the recollection of the witness other than by refreshment of memory. And I mean, I could talk about this for ages and I'll try not to. But as a general point, if you ask a witness a question or ask them to recall something that happened, you were likely to influence the recollection of the witness, right? So that's quite a difficult thing to comply with. And that's something which I don't think the best practice part of the practice direction, which is quite a long appendix, really gives enough guidance on. The other stuff is slightly more straightforward, be as concise as possible, only refer to documents if necessary. And there they say it generally won't be necessary to do anything other than list the documents that you've talked about. So you shouldn't be referring to documents. You shouldn't be kind of just like reciting and speaking to the documents. You can only really do that if it's necessary for them to prove or disprove its contents or explain how they understood it. But there's a highlighted need for caution about showing a witness any document which they didn't either create themselves or which they didn't see very soon after the incident in question. It also says don't exhibit all the documents that you're referring to, instead of having these like enormous exhibits which then get kind of cut out of the trial bundle. Include the references to the documents in the witness statement itself. Don't quote at length from the documents. Don't take the court through documents. You're not providing a narrative or a background or a setting the scene. What you are doing is giving evidence on those things which your witness evidence is required to prove. And there, I think there's a distinction, because it's recognized that in a lot of commercial court trials, the documents are actually all important. And a judge might be deciding a case by reference to the documents. He'll do that from the documents. You don't need the witness going through and saying, oh, and then I sent this email which said this, and then I sent that email and I got a reply which said that. Just stick to the bit which the witness is giving his oral evidence on. And then there's a bit about how to proof witnesses, and this idea that I referred to earlier about how to get the evidence in a way that tries to minimize the misinformation effect effectively. There's increasing recognition. I think Leggett was one of the first ones when he was a High Court judge to talk a lot about how malleable and unreliable witness testimony is. And there are procedures in this appendix to try to minimize the misinformation effect that occurs during the process of preparation for trial. So you should be proofing a witness by asking them open questions, getting them to tell stories in their own words. Don't ask any leading questions, be as open as possible, try not to refer to documents, try to record. So they recognize that the lawyers might be drafting the statement, but if you are a lawyer are drafting a witness statement, do so based on your notes and records of an interview, and don't really go beyond that. So that's the statement of best practice. The other thing that I would say, there's the ICC has done a report on witness evidence in commercial arbitration, and they have a section, I think it's section 5, that talks about how to prepare witness evidence without altering the witness memory as much as possible. And I think for people who are going to be going out there and trying to comply with this practice direction and will have to sign off the statement of best practice, that would be a very useful document to read, because I don't think this annex really gives enough guidance in itself to be able to certify compliance with it.
Well, because one of the problems is, sorry, Joe, one of the problems as I see it, I see two big issues coming out of this, right? One is for solicitors learning how to do this according to the best practice. And I know Paul would say that he's always told people, proof, don't start with documents, but I've seen it a zillion times where the first draft of the witness statement is from someone in an office going through all the documents to set out the story before that goes to the witness for them to add on. So there's a wholesale change about how you have to do this and to understand what is a leading question, how not to influence memory. And I think one of the things firms have to think about is how are they going to train? Do they need some training for their people who are doing witness statements to get best practice? The other thing that concerns me is on our side, what the effect this is going to have on trials. And if we're not going to have witness statements with all this narrative, how that's going to affect the running of the trial. But we can talk about this in more detail in a second, because, Paul, we are very lucky today to have someone right in the know with us.
We have got the very person to grill on this. We have got none other than John Kimball QC, Deputy High Court Judge and member of the Witness Statement Working Group. John, welcome to Quadcast.
You need to unmute.
John, unmute yourself.
Hi there.
So, John, I've got a question for you.
Go far away.
And we've got...
They look so nervous, John.
Right, this is it. John.
Yeah.
Look, I think everybody here, I certainly agree with a lot of the aims, and I thought the report that was produced made some very pertinent observations. However, my problem with this is, how is anybody really going to be able to apply this in practice? And I want to ask you a specific question. So 3.1 of the practice direction is the heart of the practice direction. 3.11 says you can only give evidence on matters that go to the issues, just giving shorthand, fine. But and sub 2, you can also, in a witness statement, you can deal with evidence as to such matters that the witness would be asked by the relevant party to give, and the witness would be allowed to give in evidence in chief if they were called to give evidence at trial. Now, how on earth does the poor solicitor, trembling as they will be, signing this certification, knowing that they could be hauled off to
10 years in prison,
to prison or whatever,
and days in a quarantine hotel,
for signing a false one? How are they supposed to know what amount of background information, because this is probably what this is directed at, is permissible? Over to you, John.
Well, I mean, you're right. First of all, 3.1 is the heart of it, and it's the first part of it. It really, I suppose, elevates legates' judgment in Guestmin from a bit of advice and guidance into a firm rule. Because what Guestmin pointed out was, look, in the commercial court, with the full range of emails going backwards and forwards between the parties, WhatsApp messages, text messages, most commercial disputes, the more reliable guide to what was going on is in the contemporaneous documents. And witnesses are sure they can remember things, but actually the more reliable record is there. And that was the guidance that was given. What 3.11 does is say, it elevates that into a firm rule, which is a witness statement prepared under this new practice direction must only contain evidence in relation to issues that needs to be proved by witness evidence. In other words, if you can prove what you allege in any other way, but in particular by a document, you must not include evidence about that fact in your witness statement. So that's point number one. So going back to your question, so how does a solicitor know?
No, but my question wasn't about 3.11. My question's about 3.12.
Yeah, but 3.11 is crucial, because where this all started, don't worry, I'm not dodging the question on 2.
Like a politician.
But the first part is crucial, because one of the main complaints that goes back into the Wolf Report and into the 90s and the early part of this century is that witness statements in the commercial court were overlong and over-lawyered. Too many lawyer hands working on the document that served, and far too long. 100, 150 pages, 200-page witness statements. So the idea of point 1 is to reduce the job for the solicitor by saying, first of all, work out what you need to prove using a witness. It might not be very much at all. You might only have 4 or 5 issues you're left with. So that makes the whole task easier. Then coming on to 2, well, that is, I have to admit, a somewhat curiously worded provision, because what it basically says is, in order to work out what goes into a witness statement, you have to pretend that the rule about witness statements doesn't exist.
To be fair to the drafting of the committee and Paul's question, the old commercial court guide also talked about evidence in chief. They also said a witness statement should have what you would be allowed to do in evidence in chief. So we can't criticise your drafting on this. It's a hangover from multiple.
I mean, Paul, you look very sceptical, but doesn't it recognise that this thing that you're talking about, which is the idea that actually a witness statement might be useful because it gives a lot of background, is something that isn't really the witness's job, right? And this is where submission tends to creep in, and you set the scene, you try to spin your narrative. Of
course you can. If the witness is giving evidence in chief, like at a Crown Court trial, which is what I understand the commercial court judges would quite like us to have, of course you could say to the witness, what's your job? What's your background? What's your brief CV? Of course you can ask some background questions.
Yeah, but it's one or two questions. It's not the first 17 pages of the witness statement. It's setting the context and the background. And
we all agree witness statements have gone too far the other way of trawling through all the documents, right? But then that leads to my concern. At least you then had, albeit too often and in too many witness statements, the narrative. Now, how is a judge going to know the story when he starts hearing this truncated evidence just on the 3 or 4 issues where he hasn't got it all in his head? It seemed to me now we might need even longer agreed chronologies or longer openings. It seems there has to be a balance somewhere else in the trial if you're not got it all in the witness statement.
Yeah, I was going to say, to the reader, it looks as though the practice direction is envisaging some other kind of document, perhaps an agreed one, that does that job. But it's not expressly stated in the practice direction. Is that something the committee envisaged?
Yeah, well, there are two things. One is that, Poonam, you're absolutely right, that what is envisaged is that there will be longer openings, longer skeletons, and longer closings to introduce the judge to the narrative. Because most of the commercial court cases, or many commercial court cases anyway, are really a battle between two narratives. There's the story of the joint venture going wrong from one side, and the story of how the joint venture would have worked perfectly successfully from the other side. And that is a lot of our job as advocates, is about getting the story over and getting the narrative over. Now, one way in which it's traditionally been done, for sure, is having one main witness statement, which tells the story from the beginning of the commercial relationship right to the end. And that has to stop under this practice direction. So you're right to ask, where could you put that?
Now we've got
one of the. Let me finish it, Paul, because it's important, because one of the options that was put to the consultees, 1,000 people expressed their views on what should be done about witness statements. Everyone agreed on the problem, but there was a lot of dispute about what the answer was. One of the proposals was to have a statement of facts, the sort of thing you get in a commercial arbitration, the sort of memorial, where you set out your story and you say how you propose to prove it. That was put up for discussion, and ultimately it didn't find sufficient support because people were afraid it was another layer of cost, another step in the proceedings, and they didn't want to do it. So where the implementation committee left it was that probably the answer will be in those cases where you need it, longer openings or some sort of annex to your opening.
We can't have another document to agree, because already with the disclosure pilot we have new lists of issues and.
Oh, no, it won't be an agreed. No, it's not envisaged to be an agreed document. Of course, there'll be greater concentration on agreed chronology and an agreed core bundle, but that's already there. The difference is you almost certainly will want to set out your narrative, your side of the story somewhere, and explain to the judge what documents you say prove it.
Are you going to do that already, or are they going to change? Well, there's quite a short page limit for skeleton arguments if you've got to do that as well.
That'll all be something that will just come out in the wash. But my best guess is that in most cases where you really need it, people will put it in as an annex to their opening.
Okay, now look, we've got a lot of questions coming in, so I want to give some viewers' questions here. So, John, you haven't been warned about these. So here's a question from something called C2C Pyrenees. Trying to work out what C2C Pyrenees is.
But an accountancy firm, I think.
What about the case? Because one of the things that the practice direction says, you're not supposed to comment on the documents. And this person is saying, well, what about if there's a document that reports something about that witness wants to challenge? Can they comment on that document?
Yes.
They can.
Surely.
Yeah, there's no problem with that. The thing is, you've got to be clear about what the witness's original memory was of what happened at a meeting. So when you do your first proof, which is what the statement of practice says, you don't lose any leading questions, keep it all simple, just ask the witness what he or she remembers. And if there's a document which comes out in disclosure, which presents a completely different picture of the meeting or what that person said, then there's no problem whatsoever putting that document to the witness. But you've got to keep a record of having done it, and that's got to be one of the documents in the list that you reveal has been shown to the witness to prompt his or her memory.
Okay, there's another question. This is from.
So it's all about transparency. It's about the trouble with the way we approached witness statements before is that it was like an endless polishing. It was like a beautiful creation that was rolled out at trial, 150 pages. Every last comma, the semicolon, it was a wonderful piece of work. This practice direction is about lifting the bonnet and saying, how did you get that engine to work so smoothly? It was that load of documents that you showed to the witness.
There's a lot I could say, but you've obviously read some of my witnesses' statements. But anyway, question from Ellen Yeats at Clark Wilmot. What does a solicitor do if they've got the proof now that's been done on the basis of a questionnaire? I think what she's saying is it may not have been done in accordance with the practice direction, but the witness statements are not due to be signed until after it comes into effect in April. I mean, what do you do?
You can't unwind it, right? You can't just start again and pretend you don't know and
don't rush to sign it before the deadline, or do you have to screw up all the work that's been done, put it in the bin and start again?
Well, obviously I could duck that by saying it's a matter of your professional judgment, but I put it this way, I can imagine there'll be a lot of witness statements signed at around about the 4th and 5th of April, just before it comes into force.
It's the 6th of April, isn't it?
The 6th of April it comes into force.
The first, I think it's the 6th, yeah.
But the other point is that there's a dispensation for compliance with the two statements. If for whatever reason you can't comply because of the witness has disappeared or whatever, then there's a way in which you can apply ex parte for dispensation from the certificate, and as long as you can explain why, there won't be a problem with it.
And one last question from me. I know that Joe and Claudia have got a question, I think, but this is from Emily Saunderson, our producer. So you're not supposed to comment on the documents. The documents speak for themselves. The witness deals with what the witness says. That's the basic philosophy. But she points out that often in commercial cases, you can't make any sense of the documents unless you've got some sort of additional narrative running alongside it. So there might be abbreviations being used. There might be just oblique references in an email. What about the $1.5 million or something like that? I mean, again, what do you do if you can't comment on the documents? The only way you can make sense of those documents is to comment on them.
Well, the statement of best practice actually covers this precise point, because what it says is that the fact that there may be or there is an issue concerning a disclosed document, which will include what it means or shows or doesn't show, isn't without more a reason for adducing witness evidence. Okay. So it's without more. So what is envisaged, applying CPR Part 1 and cooperation and saving costs and all of that, is that if there's a genuine problem with use of abbreviations and terms that don't make any sense to anyone else, you can ask your own witness or your client, what does it all mean? You produce the key or the translation, and you put it to the other side. And if they dispute that, then that would be a good reason for having witness evidence on it. If they don't dispute it, it's common ground, and then it doesn't need to go in the witness evidence. It's all about keeping it's not about saving costs. Unusually, this isn't about saving costs at all. It's about getting the best evidence, getting rid of all the crud and the commentary and the argument from the witness statements, and just getting what was really important, which is what the witness actually remembers.
Well, I think somebody needs... There's a lot I could say. But anyway, Joe, have you got anything you want to ask?
Yeah, John, I mean, is there not a risk that this new practice direction could be used as a pretty effective way of sort of protecting witnesses? I mean, if you've got a witness who's written some emails and you think, well, they're a little bit dodgy, you could now say, well, I don't need to prove what's in those emails with my witness because I can just use the emails. So I'm not going to call that witness. In the current situation, the other side could ask the judge to draw adverse inferences from the failure to call that witness. But it'd be pretty tricky to do that now because the party who might otherwise have called them would just say, well, I'm just trying to comply with the practice direction. Is that a risk, a potential risk?
Yeah, I can just about imagine there might be a little bit of that at the edges. But the reality is, whether you need a particular witness or not is going to be determined by your own case. And you're just going to have to, there's always a risk. There's a risk between the benefit of having the witness to prove the things you really need to prove. And then there's as we all know, there's the risk of either that witness not coming up to proof at all, or even worse, just being a terrible witness. And that's just the same judgment you have to make under this new arrangement.
But is it the same? Because, I mean, we're now being told, well, you can just prove it through the documents. So can a judge in those circumstances then say, well, I just don't think that what that person said in that email was right?
But if it's challenged, it all comes down to 3.11, which is, what are the issues? If it's part of your case that what the witness said is the position and it's challenged, then call that witness.
You're not going to know. I mean, this goes to your... sorry, I've got to come back on you because this goes to your point about, it's all in the best practice, paragraph 2.2. You deal with it if there's an issue. But issues evidentially are far more nuanced than the issues on the pleadings. You may not know it's going to be challenged until you get the other side's witness statement. It may not be apparent on the pleadings that the content of an email is going to be challenged.
Yeah, that is right. But the rules aren't going to change about service of supplementary witness statements. That's not altered at all. So if the position is that out of the blue, something that's not at all apparent on the pleadings comes out as a challenge to something that you thought was common ground, then you'll be entitled to serve a supplementary witness statement in relation to that, if what you want to say can't be proved from a document. If what's said can be proved by you produce another document, so here it is, that resolves that issue, then you don't need to call your witness. So those rules won't change.
Okay. Claudia, have you got anything you want to ask?
So I just have a question. This is something that Poonam remarked on when we were discussing it earlier, that it looks a bit odd for a witness to be saying, this is what happened and this is how well I remember it. And, this is what happened, but I don't really remember actually, or I do really remember really well. Given that the studies show that there is no correlation between how well a witness person thinks they remember something and how well they actually remember it. Case in point, Paul Downs swears down that he knows exactly what happened, what he was doing when he heard about 9/11, and he probably doesn't. What is the purpose of that provision? Because it seems that it doesn't relate to the likelihood of that evidence being correct, for example.
Yeah, I mean, it's a reaction to the problem that the judges felt that they were being confronted with, which they gave the name aspirational witness statements. So the judges became convinced, or are convinced, that under the current way things are done, quite often a witness, when first spoken to, if he or she had been spoken to, no leading questions, just asked about it, they would give quite a nuanced and balanced account. And they would say, well, I don't have a great memory of that meeting. I sort of vaguely remember. But what I do remember was that we had tacos at lunch, or whatever it happened to be. So their memory will be as it is the first time they're interviewed or proved. And then under the current system, what seems to happen is, first of all, they're shown a whole load of documents. Someone else works on the witness statement with regard to the disclosure. And what comes back is a polished, more certain, less nuanced account, which is, it's not that anyone's trying to mislead the court. It's just that the person doing the drafting is convinced the documents all stack up. And the witness goes along saying, well, that sounds about right. But
and it probably does affect their memory, right? Isn't there this point that Mr. Justice recognised that the process of taking witness statements and preparing for trial is almost tailor-made to influence people's memories, and so the witness will honestly believe that they remember really well whatever the document said happened.
It's not so much that the witness is asked for his or her opinion evidence about how good they are at remembering things. It's the question is more about when you were first asked about this, how good was your memory about it? That's what's got to come out. But that ought to come out because of the new process, which is the idea is keep it simple, as few drafts as possible, take a proof. If you need to show a few documents or lots of documents, that's all fine. But make sure you keep a list of what documents you're showing.
Because in reality, when you're proofing someone, they probably will say, "God, I can't really remember that, but let me think." And then that's what should go in the witness statement, which it doesn't go in right now.
Yeah.
And they probably do say, "Oh yeah, I remember because I was in a really foul mood that day." And that's what they're looking at for you. They're not going to grade out of 1 to 10 every single line.
No, it's not about grading. It is about getting that. It's about getting that real pattern, which is how we know we're all like this, which is that some things are not always the most important things you can just remember. And other things is that you say, "Do you know what? I cannot remember that meeting at all."
And you just say it.
Okay.
Okay, wait. We've got to leave this. And I love John for having so much to say because we only have a little time to do disclosure pilots. So we've had a few questions about this. And we just want to be clear. This applies to all the business property stuff, but it doesn't apply at the moment to the Admiralty Court.
That's right.
Right. And we're not sure why, but I'm sure that will get sorted out. Also, obviously, it doesn't apply to arbitrations.
No,
and people might want to think about whether they want to do that. Otherwise, we're going to have two different skill sets. So it's going to be kind of weird for solicitors, right?
And it doesn't apply in the ordinary Queen's Bench division. So if you've got a choice, you've got a contract dispute, you may decide, I want to do it old style.
Don't say that, please. I don't, I do commercial court. Don't say that.
I was going to bring all my cases in the Admiralty division.
That's the same as the disclosure pilot. So it brings us neatly on.
QB, desperate for work.
But John, thank you so much.
John, thank you very much for joining us. Thank you, everybody, for joining in. That's been great. John, we'll wave you goodbye.
Yeah.
And we'll briefly update people on the disclosure pilot. So I think everybody knows, unless they've been living on another planet, for the last 2 years, we've had a disclosure pilot running. Controversially, there has been, I noticed in the Commercial Court Users Committee minutes from November, there was a report back from, there was a survey done by Professor Rachel Mulheron, and it was reported there's been quite a lot of negative feedback on the, it says, the minutes say in some areas the feedback has been quite critical, practitioners clearly struggling with some aspects of the pilot. I'll talk a little bit about, we've had a few cases and I'll talk about those in a moment, but I'm just interested to know what's everybody's experience. I think Poonam, you haven't dealt with that, have you? So
I'm going to come in after that stage. And
that's too important to deal with disclosure pilot.
Way beneath your pay grade. Joe, what's your experience?
I am like the perfect level of unimportance to deal with disclosure pilot issues. But I mean, my experience of it is not positive either. I mean, it adds a lot of cost, it seems to me, at an earlier stage of proceedings than was previously the case in connection with disclosure. And you can, not in every case, but you can have a very expensive process of toing and froing about issues for disclosure, about the preparation of the disclosure review document that really doesn't achieve that much. And then you get to a cost and case management hearing or a case management hearing where if there are disputes between the parties, it's very difficult for a judge to actually fairly resolve them, because once you've got to that stage and you've already had this huge process between the parties, unless the judge has spent about 3 days reading into the case, it's difficult for them to make a fair decision. So, yeah, I'm not a big fan. But
the one thing that I did, because I read the latest thing just to sort of pretend that I knew something about this topic, the one thing the latest thing says is it's carrying on for another 6 months.
Extended, to the end of this year at least.
And there's not a lot that's going to change, right? I mean, they're going to try and tweak it a bit, but essentially it's carrying on.
Yeah, I think it will carry on forever.
It's
well, still as a pilot, but just
they're
never.
Not, I mean, the Chancellor is now the Master of the Rolls, and I think they're not going to change it. Claudia, what's your experience?
I also don't have that much experience with it, to be honest, but I have had very few positive experiences from practitioners. People don't seem to love it. They don't seem to find it helpful.
Well, actually, that'd be quite good, wouldn't it? If anybody's still watching, well, there's a lot of you still watching, so that's great. But if any of you have something positive to say about the pilot scheme, send it in by email to us, to Chambers, and we'll mention them next week, because it would be novel and interesting.
But it can't be that it's enabled you to build a lot more.
I mean, I have.
I mean, yeah, it really is.
I have had experience of it, and I regard it as pretty much impenetrable. Way too complicated. Adds costs, doesn't take costs away. I'm not a great fan. It's like all these things. It's like there's a problem. So what do? Oh, we'll just throw the whole system out. We'll recast it. Whereas maybe a bit of fine tuning would be a better way forward.
Well, it wasn't Sarah Cockrell behind the disclosure pilot, and she's now head of the commercial court. So yeah, I don't see, she was one of the big guys, so I don't see it going anytime soon. And I love Sarah, but I'm just saying that's on my understanding.
4 cases I found. There was the UTB case, that's Sheffield United. I was in that case. That's where the Chancellor said, for the avoidance of doubt, it applies now. Nobody thought it applied at that stage. So then there's FCA and Avocade, which was an application based on a previous failure to comply with a disclosure order, and the judge, it was a deputy, said no, that's not the way to go. You have to bring an application for extended disclosure and justify it all over again on the basis of the disclosure pilot. Then there was McParland, again, Chancellor. That was the one where it was said, I don't know why everybody's getting so upset about identifying issues. They're not the issues in the case, they're the issues for disclosure, not the same thing. So what was already complicated is even more complicated and difficult to agree. And then Pippi, I noticed Andrew Baker, Jay, but that's on control and North Shore Ventures, so it's not really about the disclosure pilot, I think. But okay, let me just go around, quick survey. If the choice is stick with the disclosure pilot or go back to CPR 31, what would you do? Poonam, have you got a view on that?
Yeah, I'd like to not learn all about this new stuff that I know nothing about. So let's go back to CPR 31, please.
Go back, Joe?
Yeah, go back.
Yeah, same with it.
Yeah, I think I would. I might say you could have an option of sort of like a really reduced disclosure or stick with CPR 31.
They already had that.
They had that. Yeah, okay, you're right. Okay, so that's the disclosure pilot. What's coming up next week? Claudia, franked investment income, we're going to look
at. This case, the Supreme Court. So it's about limitation and limitation in cases of mistake. And it's a very interesting Supreme Court case. I'm not just saying that because it was my brother's case. It actually overturned 2 House of Lords authorities.
They overturned one.
Sorry, they overturned one. The majority would have overturned another. And so it's quite significant legally, but it is also quite useful actually for practitioners to know about the changes, because limitation obviously important, and this is about mistake. We're also going to talk about the limitation issues that arise in cases of fraud. So yeah, it should be a really I think it'll be a really fun one. I'm looking forward to it.
So that's next week. Then we're going to take a week off, everybody, and then the following episode will come up the week after that, and we're going to deal with without prejudice privilege and the exceptions to without prejudice privilege. There's been quite a few cases on that and quite a few developments, and so we'll look at that. That leaves it for me to encourage you, if you're watching this and you haven't subscribed yet to the Quadrant Chambers YouTube channel, I think it's the UK's #1 Barristers Chambers YouTube channel. Subscribe.
What do you mean you think? How don't you check? Surely we are not. You check all the time.
Complicated.
I think he checks, and anyone that has more subscribers, he doesn't count as a proper barrister's chamber.
You get in touch, we'll beat you. Complicated algorithms, that's why there was a slight caveat on that. But subscribe now, so hit that button now, subscribe to the Quadrant Chambers YouTube channel. You will get notifications. It's not just Quadcast, we do loads of other educational programs that come out, so please subscribe and join us next week. That leaves it for me just to say thank you very much to Emily Saunderson, our long-suffering producer, and Ben Jacobs, Fish Eyes Production, who does the live streaming. It's a goodbye for this week. Goodbye.